All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. We're hearing our case 1 CA JV170493, Alexandra K versus DCS. Each side, because this is a very interesting case, and when we've conferenced the case, we discovered we have quite a few questions. We're going to do increase the argument time to 30 minutes for each side. If you want to reserve time for rebuttal, you certainly can, but you're responsible for working the time for yourself. We will clock out the podium so that you can keep track of your time. We are recording the argument, and in a few days, this recording will be on YouTube, so you can watch how you did. Because we're recording this, please identify your client and yourself so that we can keep everything straight. We've conferenced the case. We've read the record and the briefs. We're familiar with the case. So when you begin, just starting with what you want us to know. Based on our conference, so there are three areas we'd like to make sure that you cover. The first one is jurisdiction. The second one is whether Alexandra K is still a party in this case. And the third issue would be invited error as it pertains to the intergovernmental agreement. With those preliminaries done, Counsel, you may begin.
Good morning. It pleases the court. My name is Jay McCarthy, and I'm with the law firm of McCarthy, Weston, in Flagstaff, Arizona, and I represent the appellate Alexandra K, who I'll refer to as Alex. That's how she prefers to be addressed. And as you have stated, there are many issues in this case. But what I wanted to emphasize at the start is, first of all, as I think you realize, this case is, I believe, a case of first impression on two levels. One, I do not believe there's any case law in Arizona regarding the validity and enforceability of the intergovernmental agreements that are made pursuant to the Indian Child Welfare Act, Section 1919, as we have in this case.
Is either party disputing that in this case?
I don't think they're disputing the validity of it.
Or the enforceability of it?
Or the enforceability. I do not believe so. But I don't think there's much law in that area. And the reason I make that suggestion is not only 1919, but when you look at the, of course, as we know, this is a placement preference case, and that's 25 United States Code 1915A, adoption B, foster care. But C comes into play because of the intergovernmental agreement. Because C states that you can if in a case of the placement preferences under A or B, the Indian child's tribe shall establish a different order of preference by resolution the agency or court affecting the placement shall follow it. So those two components, 1919 and 1915C, come into play. But really what's more important here than cases of first impression are these children. And when I say children, plural, we have my client, Alex, has a little boy, Javier, who's 3 now. He is the brother of IG, who is the little girl that's the subject of this dependency case in this appeal, who is 5. And as I believe you know, they also have a half-sibling, AV is her initials, who is in state custody, who's approximately 8 years older. I believe the outcome of this case will determine whether these children have a relationship in the future. I believe the outcome of this case will determine whether they know their Navajo relatives. And I believe their relationship with their tribe and Navajo culture is at stake here.
Well, Counsel, I understand that this case will have very important practical consequences to the children and your client, but what we're dealing with here today are the legal issues. And I saw that the state had filed a supplemental authority in Jewel C, which if it were followed, at least supports the idea that we don't have any jurisdiction in this matter. What's your view on that?
First of all, because I jumped into the answer, I'd like to reserve 10 minutes, if I may. I apologize. I think a couple of things. I think, first of all, if you find, as the court has indicated, that the intergovernmental agreement is binding and applicable, if you look at it, they added a fourth preference, and that is a adoptive couple or family approved by the nation, the Navajo Nation. That means my client, since May of 2016, should have been the preferred placement. If she is the preferred placement, then I think in the Jewel case, it says to qualify as an aggravated party, they must have some right. And I think that because she is a preferred placement, the Jewel case is not really applicable to her.
But whose right is that? It seems like if she is asserting a right under the IGA as a preferred placement, the right is in the tribe to have that, to have its rules expressed in the agreement followed, and where that may benefit Alex, but I'd be hard pressed to say that it would give her any right under the IGA.
Well, Your Honor, here's what I would ask. If you look at the IGA, it's between the Navajo Nation and the state, and it's to implement and do training, among other things, records. There's many things in that IGA. The point is, the nation, while not intervening as a party, participated and was in this proceeding since the order in May of 2016. Lynette Mose, who is present today as well, is continually appeared at the hearings and advised the court. Now, technically they were not a party, but they made the court aware that my client, Alex, was the preferred placement. Now, I want to also just, in the first appeal, the panel in its decision where the court had not applied the Indian Child Welfare Act stated in its opinion the following: it was based on the fundamental assumption that it is in the Indian child's best interest that its relationship to the tribe be protected, citing the U.S. Supreme Court case of Mississippi Band of Choctaw Indians versus Holyfield. So if you state that the tribe has to be the one asserting a right, I think you do I think you undermine the whole effect of the Indian Child Welfare Act and the intergovernmental agreement. Because by having this, my client had the benefit of that, as did the children. So to say my client is not a party withstanding, when throughout the case law in our jurisdiction here, aggravated parties under the placement preferences have been allowed to appeal.
Counsel, can I ask you, and I assume you mean aggrieved parties when you make reference to
Yes.
that. If I heard you right, you had two reasons why you believe Jewel was distinguishable and this court had jurisdiction. One, if I hear you right, is that under the Indian Child Welfare Act, as opposed to Arizona revised statutes, that placement preferences, when they're allegedly not followed, means that a potential or a frustrated placement is an aggrieved party. Is that a fair summary?
That's fair.
What I haven't heard you yet get to is the second of your 2 points, why Jewel is distinguishable.
Well, I think Jewel turned on, if I remember correctly, that they found there was not a final appealable order, so I believe.
As to the placement,
As to the placement.
or I should say potential placement.
Yes, yes. So I think, Your Honor, I apologize. I believe that was a case where there was no termination of parental rights. The parents' rights were still intact, I think. This case, we know, is post-termination.
Right.
This has to be, I would assume, a final order, because the only thing that's going to be happening after this is resolved is an adoption.
Well, so let me understand your point, because as I read Jewel, it went on 3 points. One is intervener appellant said, because I'm an intervener, I have a right to appeal. They kicked that to the curb pretty quickly. The second was, are you a aggrieved party? And they analyzed that under Arizona revised statutes and said, no, you're not, and because you're not an aggrieved party, you have no right to an appeal. And then the third, they talked about the final order, and they kind of made some distinctions between who was seeking to challenge a placement order, saying, well, if you're a parent, that probably would be a final order subject to appellate jurisdiction, perhaps if you're a child in a footnote. But they said, because you're a frustrated placement, you wouldn't have the right. I'm not positive that they said it wasn't a final order. I think they addressed who had the right to appeal it.
I agree it was not clear to me. But I think, I respectfully, this analysis to be put in an Indian Child Welfare Act case has the effect to undermine a federal law that is incredibly important to children, because you will be eliminating a vast number of the plaintiffs that are bringing these cases up, because they are trying to enforce this federal law that views these placement preferences.
But if the tribe felt that the federal law and the placement preferences were being ignored, they could always intervene and always,
Your Honor,
assert their rights. So my concern is if we allow anybody who might have some claim to being a preferred placement, and I'm not disputing your client's position with respect to that now, but it eliminates any finality of these types of decisions and is going to leave us having appeals on every type of placement position, because I don't see a way to distinguish between the preferences in an IWCA case versus the preferences in the traditional placement under non-IWCA cases.
Well, a couple of points. First of all, I do not represent, obviously, the Navajo Nation, but to require the nation or any Indian tribe to be the ones that have to carry this burden will have a phenomenally chilling but also destructive interpretation of the Indian Child Welfare Act. The tribes, while there are many tribes, they do not have the resources to be here. So what you'll be setting up is a situation where the tribes, I wish they would have intervened, quite frankly, but I would also, I know this is not on point, Your Honor, but you'll also see the line of cases that have held that tribes have been allowed to represent themselves in court through their representative because of the importance of the Indian Child Welfare. There's a whole series of cases. Now, the only reason I mention that is the appellate courts have said, we know they're like a corporation, they should have an attorney, but we're going to make an exception because they're Native American tribes and because of the significance of the Indian Child Welfare Act. Not on point, but I think to require the tribes to have to intervene in every case when they can, I think, rely upon the IGA. They're assuming the state's going to abide by it. So I think to say, well, we got a way out of this and we can't come forward on this important issue would be a grave disservice, and I think it's a stretch. I think clearly my client, I think, has a right under ICWA and the preferred placement under the IGA.
Counsel, if we were to decide as a panel that you'll see that the analysis indicates has merit and we would follow it, does that end the matter, or is there another basis on which you can assert jurisdiction? I noticed that, and correct me if I'm wrong, the first time we heard this case, it was on special action, and we accepted special action jurisdiction.
Well, no, the first time wasn't a special action. No, it was an appeal. Yeah, it was an appeal.
Thank you for correcting me.
I think if this is not allowed to go forward on the issues, it's over. The Indian Child Welfare Act will not be complied with, in my opinion, based on the law. The IGA has not been complied with, and the children will be separated. I mean, I think...
Could we decide to take this as a special action?
Well, I'm not an appellate attorney, but I assume you have a lot of ability to handle this. I mean, one of the things that is so critical here is this IGA was never disclosed and even considered.
Counsel, can we address that? I want to hear a little bit at some point about
Yes,
whether
Your Honor.
your client is truly a party to this appeal, but it was referenced during the evidentiary hearing. So someone, I think actually on behalf of your client during redirect of the nation's caseworker, so someone knew something about something called an intergovernment agreement.
Well,
And in fact, I think you asked questions asserting that it had not been followed.
no, that's correct, but it was on redirect of Lynette Mose. It's in the August 16, 2017 transcript, page 66.
Yeah, we
Yeah,
see it.
the question was, now, is there an intergovernmental agreement? It wasn't. This was a
What
question.
was the answer, though? Is
The
it one
answer
that-
was yes. And then the question was, are they following it? No. And then the questions had to do with follow-up on her cross about, have they been providing you regular updates? Her cross-examination had a lot to do with that.
Here's where I struggle with, though, because you're arguing, oh my gosh, we had no idea that this IGA was around. We supplementally file it with this court. Trial court didn't have it. Trial court was asked to apply sort of ICWA with 3 subparts, not 4, and I hear your argument being that the IGA provides a 4th alternative that wasn't followed. The trial judge had no idea.
Well, but, Your Honor, wasn't there an obligation here to bring this before? Didn't the state have an obligation?
I think somebody who had knowledge that it existed did, and from my reading of the transcript, which is not as robust as probably others, I think it was that redirect on behalf of your client at
It was.
trial.
But here's the problem I have. We did not know when we asked the question one even existed. We asked the question because it was like if you follow the cross-examination, it was all.
I'm sorry, I got to interrupt there because there's always a kind of a principle that, and maybe this is from watching too many lawyer shows on TV. You don't ask a question you don't know the answer to.
Exactly.
And you did not ask that question as if, hey, is there an IGA? You were asking a question that implies a knowledge that there is an IGA and that implies a knowledge or an assumption that it was not being followed. And I find it, I don't want to doubt you, but I find it difficult to believe that popped into your head and you asked this question. Oh, why would you even ask for an IGA if you didn't even know it existed?
Well, because there used to be one years ago. Years ago. And this one was 2014. Years ago, they had one, and it was no longer being followed, even implemented. And I know this isn't in the record, and we're going off, but the point is, don't you have an obligation to say to a judge as a state, there's an IGA, you need to look at this, this is the law we must follow?
Well,
And is the burden on someone that doesn't know it?
Counsel, but you are asserting on behalf of your client that your client has an interest under the IGA, and whether the state, through ignorance or for whatever reason, didn't bring that forth, you knew, it's clear from the transcript, at least as I see it, that you knew about it, and it seems that it is wrong to say we didn't know about it. And
I respectfully
when
disagree with the court's
do.
interpretation. I did not know about it. If you want to have a deposition of me, but I did not know of it. I didn't know what it even said. We couldn't even find a copy of it until later.
But you asked the question.
I did ask the question, is there an intergovernmental agreement?
And didn't that, and when they said yes, didn't that, well, gee, if I've never seen that before, maybe I should look at it.
And the one I apologize because this is not in the record. I don't know if this is appropriate. There is an old intergovernmental agreement. It is very different than the one they have from 2014. That's what I looked at. I was told it wasn't, this, I apologize, this is not in the record. I don't know how appropriate this is.
So what your point is that that you didn't know about the new governing.
No, I didn't.
IGA.
And then when I found out, I reached out to try to get it because it is not a document that is easy to get. I finally obtained it. And they told me, well, there's one from 2014. The one that is a previous, I think it was from the 90s or 80s. I don't even know when it was.
Well, Counsel, to move on to the other issue that we're interested in, if we agree with you that the trial court erred in not following the IGA, I assume we would send it back down for the trial court to, to apply the IGA, but your client has been dismissed. So,
and we appealed that order as well. The October 19th order was, we did an amended notice of appeal.
Your amended notice of appeal did not specifically reference the dismissal of your client.
It referenced the order, Your Honor. The order came after the earlier order on.
Could you do us a favor? I read the record somewhat differently than that, and to best use our time here, could you, in the next day or so, give us a notice of where you believe the notice of appeal was
appealed? Yes, Your Honor.
That would be helpful.
Okay. If you remand this, I would ask you to please look at 25 CFR 23.132E. Now, that's the one that if it goes back to the trial court, we need guidance, because it says you cannot take ordinary bonding and attachment and utilize that for a good cause finding if the placement was made in violation of ICWA. That's a critical, it's a federal statute or regulation, and the trial court said it was inapplicable, basically, and we had to battle.
That's because you, and this goes back to the issue we were just talking about, you repeatedly told the trial court that they needed to deviate from the ICWA preferences.
Yes, for my client.
Right.
What I'm talking about, Your Honor, is there's 25 United States Code 1915B I referenced for foster care. There has never been a finding that this foster home, there was good cause to deviate. They never followed subpart B of 1915 on foster care. Never.
If we were to remand it, wouldn't you just take that up with the trial judge?
Well, the trial court will not take it up.
How can you say that? Because you've never presented. I mean,
yes,
your argument is that give me just a second, and then correct me when
I'm
wrong.
sorry, I'm emotional.
Your argument is that a preference in violation of ECWA can't establish, and I get that argument, can't establish the bonding. You have to ignore that. But you've never argued before that this preference violated the subpart of ECWA that made it a violation of the preference. So how would that have been properly presented to the trial court below?
Well, we had to do, when it was remanded the first time, the judge said, you don't get the right to a hearing. And we said, well, wait a minute, there are federal regulations now. And we had to do a motion, and in that motion, we outlined that. We said these are the issues, and one is we specifically spelled out, this regulation 23.132E. And at the trial court, we made objections about the court allowing attachment when there had never been a finding of good cause to deviate for foster care, and there had never been a motion for the current placement to be found to be good cause for the placement. Never. And 25 CFR 132 subpart, I think it's A, has very specific language, as does, I think it's Juvenile Rule 50.1. There was never disclosure that they were seeking a finding of good cause for the adoptive placement for this placement. There was an order by the judge. You had to disclose your witnesses within 30 days of trial. That was ignored. We had.
Counsel, can I ask you, this case became an ECWA case very late in the day, correct?
Well, it was after the termination.
Correct.
Yes.
Which is atypical, at least in my experience when I heard cases like this. It is, and which is, of course, not of record, but the child was placed with this placement for a long time.
No.
Before ICWA finding?
No.
No, that's wrong. Okay.
I can give you a cite to the record if you'd like.
Okay.
So my client tried to intervene in August of 2015.
Let me ask you a different question, and then I see your time's going quickly. When was the case found to be governed by ICWA?
I think it was May 16th, 2016. I think it's record is R149.
Okay. And when was the child placed in the current placement?
December 2015, and I would cite the transcript, the August 16, 2017 hearing, page 106, line 5.
So 6 months before the ICWA finding. But
Well,
the child,
more like 5.
December to mid-May?
Well, it was,
Counsel,
yeah, I mean, early. It was a number of months.
and certainly before the Indian Child Welfare Act was found to apply.
Yes. Now, but the case law in Arizona, Your Honor, is very clear that once you find ICWA, it's the Jared P. Glade T case, 209 Pacific 3rd, 157, you have to comply with it going forward.
Correct.
This wasn't hard. I mean, these are cases day in and day out. The state was required to file a motion, or the guardian ad litem, or the court.
And let me ask you, and then I am mindful of your time, where in your opening brief is that specific argument made? And I'll let you look in anticipation of reply if you're a rebuttal, if you wish.
And Counsel, we've asked you quite a few questions, so we'll add 3 minutes back on your time for rebuttal.
I will. Do you want me to answer Your Honor's question?
I'm happy to defer it if you think.
Okay. I will find it.
Thank you.
Thank you, Counsel. Counsel.
Thank you, Your Honors. May it please the Court, my name is Dawn Williams with the Attorney General's Office, appearing for the Department of Child Safety. We did file a notice of supplemental authority in light of the recent decision in Jewel C, and it's the Department's position that this Court doesn't have jurisdiction to hear this matter, both because this isn't a final appealable order as to Ms. K, and because it isn't, she isn't an aggrieved party.
Well, as far as the final order goes, it seems that once the stay is lifted, the adoption will go forward, and that will be the end of the matter.
It's
Right.
possible. To clarify, under the Indian Child Welfare Act, it recognizes several different types of child welfare proceedings. One of them is a pre-adoptive proceeding, which is after severance but prior to or in lieu of adoption. And the second is an adoption proceeding, which is a proceeding that actually culminates in an adoption. In Arizona, those are brought under a separate case number. And so that adoption petition is stayed right now, but there is still another proceeding that would have to occur, that actual adoption proceeding.
So once it's showing in the adoption case that this case is over with, the adoption should go forward, and once that's done, then Alex has no remedy at that point. So at least as I understand Jewel, why wouldn't it be final for that purpose?
Well, without trying to unduly prolong the lack of permanency for this child, if you look at the U.S. Supreme Court case Adoptive Couple versus Baby Girl, they discuss that the adoptive placement preferences don't even apply until competing adoption petitions have been filed. So arguably, even if this court ruled in DCS's favor or dismissed this appeal, there would be nothing to prevent her from filing a competing adoption petition that the juvenile court would then have to hear.
Counsel, can I ask, with Jewel C., that's not an ICWA case, correct?
No, it's not.
And what's your response to appellant's argument that that really is a distinction with a difference here?
I would respectfully disagree. I think that under Jewel C, the issue was the petitioner in that case, who was actually a biological relative of the child, didn't have a right to placement. And petitioner in this case has not demonstrated that she has a right to placement either. Although she may be a preferred placement under the Indian Child Welfare Act, the grandmother in Jewel C was a preferred placement. Great-grandmother, yes,
right.
Was a preferred placement under state law. And so, but that wasn't enough to give her a right to placement. The nation, petitioner mentioned the nation participated throughout these proceedings. So did the current placement foster parents. That wasn't enough to give them a right to placement.
But applying Jewel C in this case would be an extension, wouldn't it, given the ICWA? Because the ICWA placement preferences differ in content and in sort of importance, I think, compared to Arizona Revised Statutes preference, which are also important, but not perhaps equally so.
To some extent, yes, but even the ICWA placement preferences allow for the court to deviate from them if it finds good cause, which the court did here.
How do we then, it becomes a bit circular, and one of the things I struggled with on the Jewel C on the aggrieved party was it seems to me that the court looks to the merits first to see if you had a right to what you're claiming you should have gotten on appeal, and concluding that there was no such right, therefore there's no right to an appeal. Am I misreading Jewel C, or is that how you read it as well?
I think that's how our office has read it, in part because someone who does not necessarily have that right to placement could bring a special action if they felt that that was a remedy that they were entitled to, particularly if they're alleging procedural problems with how the court came to its decision.
A couple more follow-ups, and then I promise I'll be quiet for a while.
No, that's fine.
That, in fact, Jewel C there was a footnote talking about would Jewel C preclude this court from treating the appeal sua sponte as a special action?
No, this court could certainly do that. The department would ask the court not to for several reasons, the largest of which is that the department never had an opportunity to present anything about the IGA in the lower court until it was raised in the reply brief here.
And again, the one other follow-up I had under Jewel C with respect to whether the order is in a final appealable order, would that apply with equal force to DCS if DCS sought to appeal from either the grant or denial of a change in physical custody? Let me tell you why I ask that. It seems to me Jewel C says, well, this kind of order may or may not be appealable depending on who's trying to appeal it. At least that's one way to look at that third chunk of analysis. If you're a parent, you can. There's a footnote saying if you're a child, you probably can with, I think, a CF site. This potential placement couldn't. I don't know where DCS fits in that sort of continuum.
I think the court would have to do the analysis is, does this conclusively define the rights of the party? So if DCS cannot later seek a different or seek a change in placement, it would be a final order. I think in this case, because DCS always has the option and the duty to consider the child's health and safety, if something were to happen in the placement, DCS can and should change that placement. So it may not be a final order for purposes of DCS, but that would have to be analyzed in light of the circumstances of the case.
And I told you I'd be quiet, so let me violate that. But DCS could seek a change in placement, but if it was placement pursuant to a court order, they'd have no right to do that unilaterally.
Unless it was an emergency.
Right.
I would argue in the event of an emergency, DCS would have to remove the child. But yes, if it's a court order, then DCS would have to seek a court order changing that. But DCS would have the option to do so if there was some kind of change in circumstances that would warrant it. Under 8862H, once the child has been placed in a permanent placement, DCS would have to not only seek a court order to move the child, but provide the child's current permanent placement with notice and an opportunity to be heard before it could do that. And so because that statute does give DCS the option to look at additional placements, even once a child has been placed in a permanent placement, it might well not be a final order for purposes of DCS. It might be a different case for the Navajo Nation, however, because they do have an independent right in this matter to deal with the placement issue. And I think it's significant that they have not come forward and intervened in this case or even participated on appeal. Although some tribes may not have the resources to participate, the Navajo Nation has been involved in many appellate cases before this court, and many of them have involved the Indian Child Welfare Act. They're very cognizant and diligent about defending their rights under the Act.
They did appear and repeatedly, or I don't know if I should say repeatedly, at least clearly expressed their preference for Alexandra.
Yes, their social worker did make clear that that was their position.
And I don't want to, you can talk for as long as you want about the jurisdictional issue, but I want to talk a little bit about the merits because, and see if we're in agreement or if there's still disagreement. Setting aside all the procedural problems with how the record was developed below, would you agree that the trial court erred in not considering the IGA as the added fourth prong under the statute?
I don't think so, not until that the court and parties had an opportunity to explore that.
I'm saying setting aside the procedural, had the IGA, it is law, so you'd agree with me on that. It has the force of law by being incorporated in with the statute.
To some extent, yes. Because of this case, because of the issues that have come up in this appeal, we have been examining that IGA and trying to determine whether or not those placement preferences are valid. If you look at, well, the section says that a tribe can, by resolution, change the order of preference. It doesn't say they can insert an entirely new category of preferences. And so it's unclear to us whether that is even a valid exercise of the tribe's and DCS's ability to enter into that agreement to add that section. So that's something that we haven't explored, and we are actually in the process of renegotiating this IGA, and that's something that we're going to have to negotiate with the nation.
But for purposes of this case, though, aren't we bound by the IGA until it's changed or until whatever issues of validity have been resolved elsewhere?
Well, I would argue that those need to be resolved in the trial court, not at this court in the first instance. And so if there are questions about the validity or applicability of the IGA, I think those need to be resolved in the juvenile court.
And I didn't hear Judge Howe suggesting that we're reaching out to address that, but I think his question was, isn't it valid until it's deemed invalid?
Yes.
Okay. Yes, I think I can agree with that. And the issue then would become whether the juvenile court's consideration of the nation's stated preference constitutes a consideration of that preference under the IGA. The court made it very clear that it was well aware that the nation preferred Ms. K as the placement for the child.
But it wasn't aware of the force of that preference under the IGA, correct?
Correct.
So, as far as that goes, wouldn't the remedy for that to be to return the matter to the trial court for the trial court to give proper weight, whatever weight that may be, in its placement decision.
That is certainly an option. Yes.
And are you agreeing with that then?
It's the department's position that this child has been waiting for permanency for a long time, so we would rather not see this litigation continue to drag on, especially in this piecemeal way that it has. If the court is inclined to see this as a valid appeal and accept jurisdiction, the department would understand that this court would most likely remand the matter to the juvenile court to address the applicability of the IGA and the weight of that preference.
And I realize that the issues of the narrative appeal are not your issues, but Alex's counsel's point of view on what has been appealed and what has not been appealed.
According to, if you look at footnote 4 in our answering brief, counsel did include the order dismissing her as a party as one of the issues that was appealed, but never raised that in the opening brief. So the department had argued that that was waived and abandoned because there was no subject heading, no authority, no reference to it other than that it existed in the notice of appeal. And we would maintain that without actually arguing that issue, the petitioner has waived that issue.
So if we were to remand the case, where would Alexandra be? She would. Would she have a right as an intervener to be there or not?
My speculation would be that she would file a new notice to intervene, and I imagine the juvenile court would grant it under the circumstances.
Okay.
Counsel, let me ask you to return to the intergovernmental agreement. It is a document, regardless, I think, of what it says, that has great meaning for ICWA cases involving the Navajo Nation.
And DCS as well.
Oh, absolutely. And I don't for a moment mean to suggest anything else. In the state of Arizona and families. I looked yesterday on Westlaw. I did not look on the internet, but I looked yesterday on Westlaw. I couldn't find it. How something that meaningful that addresses a statute that puts the fear of former juvenile court judges, it puts the fear in them anytime an ICWA case would come because it's so different than a prototypical dependency or severance case. It seems to me that that should be available generally, because if in fact, as it's currently written, it does kind of add that fourth category, that's a really meaningful thing, and there is at least an argument that this appeal either could be avoided or would have been quite different had the trial court known of that going in. What sort of obligation is there to make those sorts of things available, quite apart from this case, so this type of appeal isn't replicated?
And that's something else that we've had to address in light of this appeal, is that the department, when this agreement was entered into in 2014, did trainings for the entire department and all of the AGs and provided a copy. Obviously, there's been quite a bit of turnover since then. In 2015, when the new regulations and guidelines were being promulgated, there were trainings statewide to address those changes to ICWA, and this IGA was mentioned in each of those trainings. I don't think, to the best of my knowledge, a copy of it was provided at those trainings. But it is something that in light of this appeal, I have requested that the department put it on their policy website to make sure that it is more easily accessible. But the fact of the matter is any DCS worker or assistant attorney general has access to it on our intranets and can provide it.
Is that policy, I'm sorry, is that policy website an outward-facing
Yes.
website? Okay,
Yes.
Thank you,
Mm-hmm.
thank you.
If it's available to DCS and to the attorneys at the AG's office, and since it governs this case, why wasn't it discussed or brought forward.
The department and the Attorney General's office had never viewed this under Section 1919 as a change to the placement preferences. It had simply never come up. And so I think that the trial attorney who was responsible for this case, it just never occurred to him that it would be an issue. And because the nation hadn't brought it up and DCS wasn't aware that this was potentially a change in the placement preferences themselves, I think it just never occurred to anyone that it would be an issue.
So, and I'm not going to put words in your mouth. Since the IGA governance and you don't take issue with at least at this point, then you're fine with it being remanded then.
If this court accepts jurisdiction, I would expect that this court would remand it for the juvenile court to consider it. I still respectfully argue that under Jewel C, this court should not exercise jurisdiction.
You danced slightly around the question, and I understand completely why, but I want to nail you down if we can. Setting aside the jurisdictional aspect, if we get to the merits of this case, how could we affirm?
The way I think this court could affirm is to find that the juvenile court did consider the nation's explicitly stated preference and nevertheless still found good cause to deviate from the placement preferences. But I understand that because
stating their preference is a little different than saying there's a statutory/regulatory agreement preference. You agree with that?
I agree with that, and I understand that that would be the basis for this court to remand it.
It would be almost, I'm not saying impossible, but let's say impossible adjacent, for us to find that the that the trial court applied the proper law in this case.
That's correct.
Thank you.
And I apologize if it appeared that I was being...
No, I used to be in your shoes, and I danced
Those
that dance
adjacencies are where
frequently.
we work.
Yeah.
Let me see if I have anything else. I would clarify, there was some discussion about when the child was placed with her current placement. The fact of the matter is there was a long transition between the current placement's parents, who were the original placement, and the current placement. And so that began in early 2015, and it was only formalized in December of 2015. So although that formal placement had only been in place about 5 months prior to the child becoming an Indian child, her placement with that family had been ongoing for almost a year at that point. And she certainly had familiarity with that family because for the year prior to that, they had been providing respite care and having family interactions with her because she was placed with their parents. I would also respectfully disagree that this court addressing this matter would somehow undermine ICWA as a whole. I think it's been made clear that there are numerous parties to this litigation who could assert the applicability of ICWA, and respectfully, the petitioner, who's a biological and legal stranger to this child, isn't the person who should be asserting those rights. That should be the child who, in this case, disagreed with the petitioner's position, or the tribe, which didn't intervene and hasn't participated on appeal. DCS, if DCS believed that there was a violation of ICWA here, there are numerous parties that could have, or even the parents prior to the termination of their parental rights. But the fact of the matter is the parents didn't even request that petitioner become the placement until their rights were being terminated.
You just said something which I was not going to ask any more questions, but now I am.
Please
you said
do.
DCS, if DCS believes that there's a violation of ICWA here, and I might be putting words in your mouth, but you seemed to just tell me a couple minutes ago that if we get to the merits of it, that the court did violate the agreement, and therefore ICWA, by not properly applying the correct standards of law. So why isn't DCS telling us to remand?
Well, again, setting jurisdiction aside, as I mentioned, DCS hasn't had the opportunity to explore even the applicability of this IGA to this
And you
particular
told us
placement.
earlier that needs to be resolved in the first instance of the Superior Court. So
Right.
it seems like you should be saying, please, we're sorry, we didn't apply IGA properly, maybe. We may have some issues with the IGA, but we want to flesh these all out in the Superior Court. Please remand.
There are a couple of reasons why we're not asking to do that. One is that, again, this case has been open since October 2013. We're at a point where this child needs to know who's going to raise her, and we would like to see this resolved. In addition, because of the jurisdictional issues, we would like to make sure we don't want there to be a concern that this somehow was a jurisdictionally defective appeal that then resulted in that being remanded in the juvenile court and us litigating this continuing ad nauseum.
But even if, let's say you went on the jurisdictional issues, and I'm not saying that, but let's say that because it's fun. If and I think DCS does have an independent obligation to ensure that ICWA is enforced and followed.
As we conceded in the first appeal in this case.
Right. So it seems to me you would not be asking us to apply this jurisdictional hurdle if you think there's an issue, or at least an issue, arguable issue of violation, and something that needs to be fleshed out below. So again, I'm kind of saying, it seems like you guys should be waiving any jurisdictional argument and telling us to remand.
I understand that. And I guess the other position that I wanted to put forward is that the department believes that the court did adequately consider the nation's position, and on several different occasions weighed the two placements and determined that the current placement was the most appropriate. And so it seems as though if this court remands and the juvenile court considers in light of the IGA, I think the most likely outcome is that the court will continue to see that all of the factors it addressed in its order on two separate occasions now continue to be true, and that this child should still remain in her current placement. And so to some extent, it does seem to be...
Can't know that because she did not apply below the correct legal standard. So we couldn't affirm on that basis. If we reach the merits, we have to send it back.
I would agree.
Thank you.
Thank you, counsel.
The court has no further questions.
Thank you.
Thank you.
Counsel?
Hopefully I won't look too befuddled, but I found two spots, Your Honor, that I would ask you to look at. Sure. In the opening brief, beginning at page 36, Alex brings up both 25, I'm going to look at page 36 is where it starts, and it goes over a number of pages. But on the top of 37, it talks about the deviation under foster care, which is the B section of 1915 and A. And we talk about how that has never been presented. In the reply brief, it is also addressed beginning at page 5 of the reply brief. And what I want to emphasize, and I apologize if but there was never a motion before the trial court to find good cause to deviate for foster care for this family where the child is, or the adoptive placement preferences. This was not an issue that was before the trial court. The finding they made, the trial court judge, was not properly there. And DCS tries to say if you look at the response to Alex's motion, we had to file a motion when it was remanded the first time. And they filed a response, and their response basically says, oh yes, there should be a hearing because both the foster parent and Alex are not Native American and preferred, there must be a hearing. If you look at 25 CFR 23132, which is also, I believe it's Juvenile Rule 50.1 now they have, it says very clearly what your requirements are to set forth the grounds. And I would ask you, look at what they're pointing to in their motion. It just says there should be a hearing. It doesn't say any reason. It doesn't say, it just says there has to be a hearing now. I mean, we were walking into an ambush. We had no idea the judge was considering this because it was never before her. The other issue is if you look at the disclosure requirements, and if you say in juvenile court those are just as important as they are in other trial courts, look at they never disclosed anything about the placement preferences as to finding a good cause for the current placement. The trial judge had ordered everyone to provide disclosure and witnesses 30 days before trial. We did that. Alex did that, I should say. We got one from DCS 7 days before trial. The trial court, we said, we can't, what's all these people? So what I ask you to please do is also please look at the issue of I'm repeating myself, I apologize, but 25 CFR 23.132A, which sets forth that, and B, the burden of proof was on my client. This whole case, it never should have been, because of 25 United States Code 1919 and 25 USC 1915C, which made her a preferred placement. The burden of proof was put on my client, and it should have never been placed on her.
Let me ask you a question that came up during the state's argument, and I kind of gave me some, I don't know, some tickles in my brain on how we should be thinking about this case. Could you respond to her assertion that this isn't as final as it might seem, because your client could assert a competing adoption petition, and therefore the real issues would be resolved then, as opposed to just the temporary placement issues that we're dealing with now? And if that exposes some kind of huge ignorance on
so first of all, adoptions are confidential proceedings. We will never have notice. We will never know. We had to move to get a stay because they were going to try to get this adoption done before this appeal was heard.
Right, but you could, knowing what's going to happen now, you could lodge a competing adoption petition.
Well, theoretically, and would the court deny it because they said the placement preferences have already been decided? I mean, I don't know how an adoption judge is going to say, well, I'm going to disregard everything at the dependency level. Now, what's happening now is my understanding in Maricopa County, the dependency judge assigned is going to do the adoption. So you really think we're going to walk in and file that, Your Honor, and they're going to say, oh, we can disregard this finding, that it's not res judicata already? I think the issue really is when you make a finding of good cause to deviate, setting that aside, how do you do that? I don't know how you could file a petition and the court would say they'd have jurisdiction to set that aside.
But
it would be...
Okay.
Yeah.
I'm
sorry.
Question I had, the state concedes that you properly included in your notice of appeal the fact the dismissal of your client as an intervener, but you make no argument on that.
Well,
and typically we would, we can't construe that as, a position, and I'm not sure, what we do at that point.
Well, Your Honor, in my ignorance, I believe that my client was dismissed because they had denied her request. Why she intervened was for a finding of good cause, and that was denied, and the judge dismissed us out. Quite frankly, that was my belief.
So it's all one.
I thought it was like Siamese twins, so to speak. I would also ask the court to please review the opening brief beginning at page 26, I believe. I think it's really important that you see how important the sibling relationship is in this case and the attempts to create one. These children are not even 2 years apart. And don't these children deserve to have a relationship? And if you look at the record, I believe you will see that that is not what happened in this case. My client had to, and it's in the record, go in and get an order just for sibling visitation, and then that never occurred. She had to file a motion to compel, and of course the judge dismissed that because she denied the good cause thing. It was like a series of orders came out. But beginning in the opening brief, I wanted to direct you to it at page, I apologize, I want to say there's a lot of brief here, page 26 and 27 and 28, I believe is. I think it's important to understand that is something these children can't lose. And as the court said in the first decision, they shouldn't lose their contact with their tribe. I mean, I would ask you to look at the record because the foster parents' hostility to the tribe is spelled out. I mean, it's in our brief. We cite the record, the testimony
Thank you, Counsel. Your time is up.
My time's up. And thank you for the additional time, and I appreciate that.
Thank you, Counsel, for your argument today. We really appreciate you taking the time to answer all of our questions. We will take this matter under advisement and will issue a decision in due course. We stand adjourned.